Okay, greetings, everyone. I'm Doug Eakley, and on behalf of the Rutgers Law School Center for Corporate Law and Governance and its blockchain and fintech program, I want to welcome you to the most recent in our distinguished speaker series. And before we get to our distinguished speaker, the head of our blockchain and fintech program, Professor Yulia Usova, will be here to add a few words of perspective.
Thank you, Professor Eakley, for the introduction, and really welcome all of you to the fintech program of the Rutgers Center. And we're honored to welcome back to Rutgers our distinguished speaker, Stuart Alderoty. But before we begin, I suggest we do something that I usually do with my students. And we start, oh, the filter is not working. No, not working. Let me move over here. Can you still see me? Can you hear me? Good. So let us start with the background story. Creative, some hope. Right now you're sharing. Yes, but some technical assistance is needed. Oh, the mouse is working. Yes. Now at least one device. You see, it's all about fintech, right? And finally, we'll try to solution. So with my students, I usually cover Ripple as a whole case study, and it's a momentous and a very important case study for the whole crypto industry. So, but let's talk about two separate things. One is Ripple, a firm, and another one is XRP, which is a crypto asset with its own XRP Ledger. So how does it work and how did it all begin? It all started about 10 years ago with a group of developers who started to express concerns about Bitcoin and the fact that Bitcoin mining was pretty expensive in terms of its environmental impact. So they later on started developing a solution, which became the XRP Ledger. And after that, they also, some of them founded Ripple. In theory, they were right about Bitcoin. So you can look at the chart, the data for itself. To be honest, on an annual basis, Bitcoin mining consumes more electricity than some countries, including Argentina, Norway, and a few others. So the XRP Ledger was launched in part as a solution to this problem. It happened in 2012. And in a way, it's similar to Bitcoin. It enables transactions between users directly. And the mouse is not working. There we go. So, XRP Ledger and its use cases. The validation process for the XRP Ledger differs from that of Bitcoin. For one, there is no mining, and all tokens have been pre-mined. Also, the consensus protocol is different because there are trusted nodes. This is what makes transaction processing much faster on the XRP Ledger. So today, various firms, including Ripple, among others, use the Ledger for various business purposes, such as payments, providing liquidity solutions, building exchanges on top of the Ledger, DeFi applications also on top of the Ledger, and many others. And there is also a separate NPO called the Foundation, which helps developers to use the XRP Ledger. Now, Ripple started using the Ledger and became an international company. And in 2020, something bad happened to Ripple, specifically the US Securities and Exchange Commission, and that's why we're here, filed a complaint against the company, arguing that Ripple engaged in an unregistered offer and sale of securities. Now, let's try to remember what was going on a couple of years ago. There was a lot of regulatory uncertainty. We had several statements from SEC staff about the functionality and decentralization of blockchains. We had the 2019 framework also from the SEC staff, and there were several enforcement actions which resulted in very fact-specific decisions. And all the while, other countries, including the EU, Singapore, and many others, were developing guardrails for the industry. Now, what's going on today in terms of regulatory certainty? We still do not have a specific piece of legislation. What we do have is several bills which were introduced this summer, and yet no legislation, which means that enforcement remains key to crypto asset regulation. And that is why Judge Torres's decision in SEC v. Ripple is so momentous. It's a pivotal point for what is going to happen with not only crypto assets, but also tokenization. And it has not only doctrinal implications in terms of what is a security in the world of crypto, but also market microstructure and infrastructure implications. And with this, let me turn the floor over to our guest and Professor Eakley.
And turn over the microphone as well, if you would.
There you go.
Yeah. This is Stuart Alderoty, who is the General Counsel of Ripple Labs. And I'm very proud to say to him, welcome back, Stu. Thrilled to be here. Mr. Alderoty is the graduate of Rutgers Law School. He's also the chair of the advisory board of the Center for Corporate Law and Governance, and a friend, and we were absolutely thrilled when he agreed to come over and talk to us about what he's been living through for the last several years. So what could we start with just a little bit more of the sort of the business plan for Ripple Labs, its relationship to the XRP Ledger, the XRP token, and the 7 years that elapsed from when you started Ripple first started raising funds to December of 2020, when the SEC basically said what you've been doing is selling investment contracts and we're going to shut you down.
Yeah. So Ripple is celebrating its 11th anniversary next month. We're still a privately held company. We built up from the handful of developers and founders to over 900 employees now globally. Our principal office is San Francisco, but actually San Francisco now represents less than 50% of our global employees. We have offices in San Francisco, Miami, and New York, but also in London, in Ireland, in Dubai, in Singapore, in Brazil, and a number of other offices around the world. Ripple, I think, is the only company. That's the reason I joined Ripple 5 years ago after practicing law on the East Coast with big law firm, and then in banks. I think it's the only company that has successfully married the promise of blockchain and crypto and solving for a real world problem. And the real world problem we solve for is how do you move value on behalf of institutions, banks, and payment providers real time. Right now, traditional financial plumbing allows you to move IOUs real time, but then the banks need to settle that on the back end. And the way they settle that is a bank hires a bank, they pay another bank, that ultimately pays the bank they owe the money to. And that can take 3 to 5 days. It can be very costly. So although you may see something on your app that shows that you have the money, again, the real value has not transferred. What Ripple has done, both with our proprietary software and with the XRP Ledger, which is a blockchain, using this digital asset XRP, which is crypto asset like Bitcoin or like Ethereum, we can move the value real time. And the founding mission of the initial brilliant engineers who put all of this together, their vision was the internet of value. Just like you can move just like I can send an email now across the world, and I don't know what server the recipient was on, and the recipient doesn't know what server I'm on, and I probably don't know what server I'm on. I can hit send, and that email seamlessly, instantaneously moves to the receiver. And essentially, that's what we do with value. That's what we do with money. It actually settles. And we've been doing that, and we've been trying to perfect it. And again, we've built a very successful business, but that business relies on the XRP ledger, just like there's a Bitcoin ledger and Ethereum ledger, there's an XRP ledger. And it relies on the digital asset XRP, which we believe is faster, cheaper, more transparent to move than other digital assets. And in 2018, the SEC sent a letter of inquiry to Ripple saying, tell us about your business, and we want to understand how you use XRP. And at the time, we knew that the SEC was trying to solve for how to regulate crypto. And there was something going on in the industry called ICOs, initial coin offering, that a lot of people were skirting initial public offerings through initial coin offerings, and the SEC was trying to crack down on that. But Ripple had never conducted an ICO. So we cooperated with the government for over 2 years in an investigation, thinking that at the end of the day, we'd be able to convince them that what we were doing was completely above board and within the guardrails of what the law provided. The SEC's take on crypto, or response to crypto, continued to grow more hostile. And eventually in December 22nd of 2020, a few days before Christmas Eve, on the last day of then SEC Chair Jay Clayton's administration, we filed the lawsuit. Left the next day. We were sued. Our chairman was named, and our CEO was named personally. No allegations of fraud, no allegations of misrepresentation, no allegation of consumer harm. The sole issue was a technical issue under the Securities and Exchange Act of 1933. When does a digital asset fall under the jurisdiction of the Securities and Exchange Commission? Because the Securities and Exchange Commission only has jurisdiction over securities. So if you look at the definition of what a security is in the 33 Act, it lists a bunch of things, starting with the traditional share of stock. And it goes through about 25, 26, 27 definitional items, and you get to something called an investment contract. And they allege that the token, XRP, as distributed by Ripple, was an investment contract. And that was the issue that we joined. We joined issue with the SEC on that. And that's the issue that we decided to fight. And the SEC, I don't think, expected us to fight. They expect most people to surrender because either don't have the wherewithal to fight, or I was trained as a lawyer not to pick fights with regulators, but we didn't pick a fight with the regulator. The regulator picked a fight with us. And we felt that this was an important issue for the industry to get right, and it was an important issue to issue for the survival of Ripple, because our entire business relied on this tech stack that involved XRP and the XRP Ledger. As the dean said, we had been conducting business for 7 years, and then we were sued. And the allegations of the complaint went back from 2013 to 2020. So essentially attacking the full 7 years that we had done business, alleging that everything that we had done involving the digital asset XRP should have been registered with the SEC as a security. That was a long wind up, but hopefully I captured. Yeah,
indeed. So issue joined, absolutely exhaustive factual discovery. And I think most expert discovery was also concluded. And then the parties cross-moved for summary judgment. And that brings us to the decision by Judge Torres that came out in July.
Yeah.
And why is that decision so momentous, or what we call epic?
So let me I'll first talk about the process, then I'll talk about the decision. 2 years of investigation before the SEC sued us, and 2.5 years of litigation after they sued us. The seminal case, the Supreme Court case from 1946 that controls this issue, we'll talk about that in a moment, called SEC versus Howey. That case in 1946, from the filing of the complaint against Howey, through the district court, through the Court of Appeals to the Supreme Court, was an 18-month process. This was 2.5 years. So the SEC, part of it is the process is the function. Our CEO has talked publicly about this. We have spent well over 100 million, probably 150 million at this point in defense costs to get to where we are. But we fought, and we defended robustly because we thought we were right. And cross motions for summary judgment, which hopefully you got to that point in your civil procedure class. Summary judgment, you're both saying, okay, we spent 2.5 years discovering facts, exchanged millions of pages of documents, put everyone through painful depositions, but guess what, Judge? There are really no issues in dispute. We know what Ripple does, we know how we distributed XRP, the facts are not in dispute, you can decide this issue as a matter of law. And we argued a few things. We argued, number one, that in applying this statute, the first thing you need to do is look at the words of the statute. And the words of the statute say that we need an investment contract. And we believe for there to be an investment contract, we need a contract for an investment. And we went back and we scoured all of the law, beginning with the 1933 Act, pre-1933 Act, the Blue Sky laws, hundreds of years of civil jurisprudence. We couldn't find a single case where an investment contract was found without a contract for investment. Moving on from that, we said, even if you find that you don't need a contract for investment, you just want to apply this case, Howie, let's apply Howie. And I'll just spend a minute on Howie. So 1946, you have an Orange Grove Collective in Florida. The Orange Grove Collective decides to sell slivers of their orange groves to a bunch of tourists who come down to Florida, New Jersey dentists and doctors. So they come down to Florida, they buy slivers of orange groves, and then they go back to New Jersey. But they don't just sell them the orange grove sliver, because they did that, that's just a land deal. They said, we'll sell you the orange grove, that little sliver of land, but we'll also sell you a management contract where we'll plant the orange groves, we'll fertilize the oranges, we'll pick the oranges, we'll sell the oranges, and to the extent we have a profit, we'll deliver those profits back to you. There, the Supreme Court said that's an investment contract, because you have an investment of money, that's your first prong, in a common enterprise. The tourists from New Jersey entered into this common enterprise with the Orange Grove Collective, the business venture. And then you were expecting profit relying on the efforts of others. In other words, I didn't have to do anything. I just went back to New Jersey and I collected the check. If you have all three of those prongs, you have an investment contract. And we argued that the SEC couldn't satisfy any of those prongs. On investment of money, a lot of the distributions that Ripple made of XRP were not from exchanging money. We gave it to developers for developer grants, we gave it to charity for charitable purposes, some it would be used for compensation for employees and executives. Second, we argued that there was no common enterprise. If someone were to buy a unit of XRP on a secondary market, you can go onto Coinbase right now on your phone and buy a unit of XRP. You're not entering into a common business venture with Ripple. And then third, even if you're buying a unit of XRP, and you may know a little bit about what Ripple is doing, what you had described earlier, maybe you think that's a pretty unique use case. And maybe you kind of say, well, I'm buying because I think Ripple is going to get it right. That's not the type of reliance on the efforts of others that the Supreme Court contemplated, because I didn't promise you that I was going to do that. We could change our business model tomorrow. You could be a purchaser of the digital asset on Coinbase today, but I have no obligation that I'm going to continue to do what I'm doing today, tomorrow. And if I did change, if Ripple did change its business plan, you have no recourse back against Ripple. If you think about the Howie analogy, if Howie Orange Grove Collective decided on day 2 to stop growing oranges, you would have recourse against Howie because they made a promise to you that when you went back to New Jersey, that they were going to develop that orange grove and send you profits. So up until this point, the SEC had never lost one of these cases, principally because nobody had really never challenged them. Most people just surrendered and settled. And on July 13th of this year, Judge Annalisa Torres in the Southern District of New York issued a 34-page decision where she found that she divided the world into three buckets. So these were three buckets that the SEC divided the world into. One, institutional sales, sales of XRP that Ripple had made to institutions directly from 2013 to 2020. The second bucket were programmatic sales, sales that take place on crypto asset exchanges like the Coinbases of the world. And then third were other distributions. On institutional sales from 2013 to 2020, she said those do have the attributes of an investment contract because Ripple and entered into a contract with a sophisticated investment firm, venture capitalists. There were obligations one way or the other. Those are investment contracts. But she found for the programmatic sales, for the trading that takes place on a secondary market crypto asset exchange, no investment contract. Because the buyer doesn't know who the seller doesn't know who the buyer is. And there's no reasonable reliance on the efforts of others as imagined or by the Howey report, right? And on the other distributions, she found you don't even get past the investment of money from, because those are the charitable contributions, the employee compensation, the developer grants. So the SEC lost on everything that matters to them, because they want to create a world, and Stuart Alderoty testified for 4 hours before the Financial Services Committee today in Congress. They want to create a world where the digital asset itself is the security. And when they draft these complaints, they talk about crypto asset securities and a market for crypto asset securities. That's like saying there's an orange grove security, or oranges are the securities. And when it comes to investment contracts, you look at the transaction. So this is what's so important about the decision, and this is why the decision is landmark in this country, is the court found that the token itself cannot embody the attributes of an investment contract that's contemplated by Howey. So the token itself is not the security. Certain transactions involving that token may be investment contracts, but the token divorced from that transaction is nothing but a token, just like the orange is divorced from the Orange Grove Collective, and that promise between the seller and the buyer are just oranges. That's what makes this decision so important. We would have liked her to go so far as to find that you needed a contract for an investment, for there to be an investment contract. But she said she felt she didn't have the power to go that far as a district court judge. But coincidentally, she only found an investment contract in those instances where there was a contract. So even though she said, I'm not going to go that far, if you actually read the opinion, she kind of did cabin the opinion that way. And if the case does make its way up on appeal, which it probably will, if it gets to the Supreme Court, which maybe it will, I kind of would hope it will. I think we'll win on that contract. We'll win on that statutory construction argument. But the finding that the token itself is not a security, and the token itself cannot embody the attributes of an investment contract, that's what makes this decision so very important.
So in its motion for leave to appeal, the rulings on the programmatic sales and the other distributions, well, on this motion, the FCC argues in part that there's a split in the district thanks to a decision rendered by Judge Jed Rakoff in the Terraform case just a few weeks after Judge Torres came down with her opinion, and the argument there was basically Judge Rakoff said it doesn't matter whether it's a direct sale or purchase or a secondary exchange. It's all the same thing, and it's all covered by Howey.
So the SEC does not yet have the right to an appeal. And again, we have a lot of students who are learning online. I'm not sure where you are in your civil procedure yet. You only have a right to appeal from the final judgment that resolves all issues as to all parties. Despite the judge's ruling, there's still some open issues on those institutional sales, so we don't have a final judgment. So the SEC does not have a right to appeal. So they have to ask the court permission to file what's called an interlocutory appeal. And there's certain legal standards that you need to satisfy for the judge to give you that permission to file an interlocutory appeal. And the presumption is you're not going to get the interlocutory appeal because it's really judicially inefficient. You take piecemeal issues up to the Court of Appeals and then come back down and go back up and come back down. So one of the things that they pointed to is to say, look, Judge, you ruled on July 13, just as I had described earlier. But about a month or 6 weeks later, Judge Rakoff, another judge in the Southern District of New York, right down the hall from you, in another case involving digital assets, found that second and distinguished your case, finding that secondary market trading of programmatic buy sells on the Coinbases of the world could be securities. And we have a difference. I think that's an overstatement. Our case came after 2.5 years of fully developed record on summary judgment. Judge Rakoff's opinion was on a motion to dismiss. And on a motion to dismiss, at the beginning of the case, you have to accept all allegations as pled as true. And as alleged in that case by the SEC, that when Ripple Labs was promoting their tokens, they had promoted or promised the buyer of the token, no matter who that buyer was, no matter the platform on which they bought the token, that token would yield 12 to 15% in returns. So accepting that allegation is true for purposes of the motion to dismiss in 46 days, the judge said you can have a world where a secondary market purchaser is relying on the efforts of Ripple Labs. But I think given the procedural differences in the case, there's a lot of separation in terms of what Judge Rakoff meant and what the court said. And also, I think if you read Judge Rakoff closely, well, firstly, you need to know that he tends to say more than he needs to say in his decisions. And he probably said a little bit more than he needed to say in this decision. But he also recognized that the technology itself is probably not in and of itself the security or the contract for investment. But here, enough was alleged that the promises that were made were kind of embedded into the technology. So where that case ends up remains to be seen, and whether Judge Torres grants permission for the interlocutory appeal remains to be seen.
Although the SEC also moved to stay the further proceedings in the district court while its motion for leave to appeal was pending.
And the judge denied that. So we have this perverse dynamic going on with the SEC and our case. When we were litigating with them over the 2.5 years, we were trying to accelerate things. We were trying to move things as quickly as possible to get to a decision, and they wanted to slow things down. Now that we won, they want to stop everything and they want to hurry up to the Supreme Court. And we're like, no, not so fast. We kind of like the ruling, and the law of the land as it sits right now is pretty sweet for us. So let's go through the rest of the proceedings that we need to go through at the district court. Then we'll bundle all of the issues together. We'll bring those up to the U.S. Court of Appeals for the Second Circuit. And oh, by the way, if you want to appeal the programmatic sales and the other distributions, we're also going to challenge Judge Torres in fact that she didn't want to go so far as to find that you need a contract for investment, for an investment contract. But let's bring all of those issues up to the Second Circuit.
So on the second issue, the other distributions ruling where the judge found for Ripple, the SEC is taking that, or attempting to take that up on appeal, essentially arguing that well, in one Supreme Court case, the International Brotherhood of Teamsters case, the court ruled that an investment need not take the form of cash only, but can be goods and services of value, and therefore there was error in saying that the distribution of XRP tokens to employees as part of their compensation did not meet the Howard test.
That's right. So The Teamster case does say that, an investment of money can take the form of something else other than the exchange of money. It could be the exchange of consideration. But what that case also said is that, going to work and giving my services as an employee in exchange for something does not rise to the level of an investment of money, because I have a lot of incentives to go to work. In that case, it was whether the pension and notes that were embodied in the pension constituted a security. So even though the SEC correctly cites the sentence or the two sentences from the Teamster case, again, oftentimes what I found with the SEC, when I actually read the cases don't really support what they're saying. And I think the Teamster case ultimately will support our position. Because again, if you go back to Howie, what the Supreme Court was trying to do in 1946, and it's still, I think, legitimate today. If you have your stocks, you have your bonds, you have your notes, you have all of these things that we traditionally think of as securities. But then you've got a lot of really smart, crafty people out here who are going to try to do a lot of different things to sell people stuff that is going to yield an investment to them and take their money. And that goes back to the blue sky laws that predate the 1933 Act. And that when the Supreme Court talks about an investment money, they're talking about it in that context. So when I go to work for Ripple, I get paid in cash, I get paid in Ripple stock, I get paid in XRP, but I don't show up every day saying, I'm exchanging my services as chief legal officer because you're going to give me XRP. That's not the relationship that's contemplated, I think, by the Supreme Court when they talk about the investment money from and how it is.
So one of the things that strikes the reader, and both the decision and also in the briefs in support and opposition to the motion for legal appeal, is just how fact specific the Howie inquiry is, and how grounded Judge Torres's decision is in the facts that were developed over the course of 21 months or whatever, prior to the motion for summary judgment being filed.
Yeah. Well, the first legal standard that you need to satisfy to be granted an interim or an interlocutory appeal is that there is a controlling issue of law in dispute. And if I were to settle that controlling issue of law, it could resolve not only this case, but other cases, which is an odd position for the SEC to take, because the controlling issue of law here is Howie, but it's Howie as applied to facts that they don't like, and it's Howie's applied to facts resulting in a decision where they lost that they really don't like. But that's not one in interlocutory. That's not the standard in interlocutory.
So unsurprisingly, or perhaps unsurprisingly, the decision of the court unleashed an avalanche of comments in the blogosphere. And one of the suggestions was that Ripple came away with a split decision in this case.
Yeah. So the decision had ripple effects, excuse me, throughout the entire world. It really did. Regulators in Singapore were called, in Dubai, in London, in Ireland, Canada, everybody was paying attention to this. Because the SEC was peddling this false narrative that a digital asset in and of itself could be a security, and therefore we get to control the entire crypto industry in the US. Having lost that, it got a lot of the attention of a lot of regulators outside the US. It got the attention of a lot of politicians inside the US that have been trying to solve this issue, who've been told for year after year after year by the chair of the SEC that I'm right and trust my regulation by enforcement strategy, and we'll get to the right place. And also, well, now we have a judge disagreeing with you. There's been multiple judges disagreeing with them. But the SEC, who never commented publicly on our case in 2.5 years, as soon as the decision came out, they issued a press release calling it a split decision. And I found that pretty telling, because number one, I think it was a recognition that they lost in a way that hurt them. And number two, they were trying to weaken the impact of the decision. And the split decision piece that they were talking about is those institutional sales from 2013 to 2020. They say, well, you see, they lost on that. Yes, we lost on that. Would we have preferred not to have lost on that? Yes. But they lost on everything that mattered to them, principally this concept that a token itself is not the security. Without that, if the SEC wants to continue down this campaign of regulation and enforcement, they're going to have to file suit after suit after suit to go after every digital token that is out there, which is not the way that this country should be solving for how to get a rational regulatory framework for the crypto industry.
So you've used the term twice in that last response, but what do you mean by regulation by enforcement, and why is that somewhat inappropriate for a regulator dealing with a new asset classification and industry?
So regulation by enforcement is when you have an area of the law that exposes a regulatory gap, and I think crypto has exposed a regulatory gap, rather than solving that gap through rational rulemaking, through collaboration with public-private partnership, through publication of rules, comment, through a legislative process, you file enforcement actions in the hopes that the company on the other side of the enforcement action will have no choice but to settle, because most people don't have $150 million laying around to fight the government. And then you take that settlement and you start stacking one on top of another on top of another. And they've had about 150 of these settlements and saying, you see, this is the Wild West. And when we challenge these folks, they settle, and they must be settling because they're wrong. And the law is clear. The law isn't, there's no uncertainty in the law. And they try to plug that gap of uncertainty through a campaign of regulation by enforcement, which is not the way it should be. And that's an additional reason why I think our outcome is so very important, because it exposed the uncertainty. It exposed that the uncertainty can't be filled by the SEC. It has to be filled by a rational policy framework, which is happening everywhere else in the world, which is why when I talked earlier and introduced Ripple, it's important to know, why do we have 50 employees in Singapore? Why do we have 40 employees in London? Why did we open up an Ireland office? Why are we growing our Dubai office? Why are we growing our Sao Paulo office? Because that's where we can do business. And we do business here, not because we want to run away from it. We do business there because the regulators have developed a clear framework, often a licensing framework, that if you submit to that licensing framework and you submit to their supervision, and they can assure themselves that your business is being conducted in a way that protects consumers, protects the integrity of the market, and keeps bad actors out, will enable the technology, will enable the entrepreneurship that goes into this really great innovation on this crypto. And that the US sadly is really falling behind.
Actually, the decision itself reflects or reports that multiple foreign regulators, including regulators in Japan, Singapore, Switzerland, the UAE, and the United Kingdom, have determined that XRP was not a security.
That's right. And because it's not a security, because it doesn't represent a right, title, or interest in the company called Ripple. If you want a right, title, or interest in a company called Ripple, go on to even not publicly traded, but go on to EquityZen or one of these other online platforms where you can trade private stock. Go out and buy Ripple shares. That will give you a right, title, or interest in Ripple. Buying a unit of XRP does not give you a right, title, or interest in Ripple. It's a very simple, straightforward, commonsensical approach that every other regulator in the world has recognized, except for this regulator here in the US. And I believe they're advancing politics and power over sound policy.
So we'll come back to the sound policy if we have time, because I want to talk about pending legislation and preferred legislative models for where do we go to fill the gap in a rational way, but. Just back to the split decision for a second, that argument, the SEC did mention that Ripple's contention is that a large portion of those institutional sales were to foreign purchasers. And there's a U.S. jurisdictional issue under Morrison as to whether or not they fall within, assuming there's jurisdiction in the SEC, whether they fall within the U.S. jurisdiction.
Well, that's, you know, one of the several reasons why we're opposing the request for an interlocutory appeal, is we still have to go through a remedy hearing on this one piece of the case around the institutional sales. We have defenses, again, assuming that they're securities. We have defenses, number one, that to the extent those sales took place offshore, the extraterritorial reach of the SEC's jurisdiction doesn't reach that far. We have a defense that all of those counterparties were sophisticated entities, accredited investors, would have been subject to other exemptions under the securities laws. So all of those issues still need to be resolved for the institutional sales.
So I think again, the SEC claimed that the court ruled against Ripple on its fair notice defense. This defense that this action by the SEC was unprecedented, and under due process, you had no advance notice that they were going to prosecute.
So one of the key defenses in this case and in others as well is that the way the SEC has behaved, they've created uncertainty in terms of what the law requires when it comes to running a crypto business in the US. And the law in the US requires that a person of ordinary intelligence, and that's certainly me, needs to understand what the law is before you can be called into a courtroom and charged with violating the law. And the SEC said, Judge, the law's clear. It's Howey. It's 1946. It's been around for 75 years. They changed it to 2-1 appeal. So it's clear. And what the judge said, look, on the institutional sales, because we have contracts for investments essentially, you have fair notice. But as to the programmatic sales on the exchanges, as to the other distributions, I am not ruling as to whether or not there were fair notice violations here, because I don't have to. Sure, she kept that issue very much alive. One of the things that Judge Torres did that she got so very right, and you'll learn that once you start practicing law, judges who agree with you are brilliant. And Judge Torres is just, she's a brilliant judge, but all kidding aside, the more I read this opinion, it really is like I'm not a wine drinker, it's like a fine bottle of wine or fine, it just gets better. Because what she only decided that which she needed to get right. And she didn't decide that which she didn't need to decide. So for example, if she found on the other distributions that there was no investment money, she said, I don't have to decide whether there's a common enterprise. I don't have to decide whether there's a reliance on the efforts of others. I don't have to decide whether there's a due process violation. She kept all of those issues undecided, which we think is a great thing. Because if it does go up to the Court of Appeals, and for whatever reason the Court of Appeals would disagree with it, which I don't think they will, it probably gets remanded, and then she just has to decide all of these other issues.
So I should know the answer to this, but my last question before we turn it over to our guests. Has Ripple taken a public position in terms of the legislative model that it would like to see the Congress adopt?
Yes, we've been engaging with regulators since the long before I got to Ripple 5 years ago. Our CEO and I spent a full day in Washington on Tuesday, I think it was. We met with the Financial Services Committee, we met with other committee leaderships. We are very supportive of a legislative solution. We want to see this industry grow. We think it's tragic that the technology, the tax dollars, the jobs are being moved offshore. I was joking earlier, we don't want to see 25 years from now to bring the blockchain back, to the US back and to invest, $100 billion to get the technology that we lost. So we need a comprehensive regulatory framework, and we're supportive of a rational regulatory framework that doesn't give the SEC greater authority than they would have under the current structure. So the one thing we do worry about is, as you try to educate policymakers about this very, very complicated subject, you can have some proposals that are trying to fix the uncertainty, but they're going to do it in a way that potentially you give the SEC more power to abuse. And that's not what we want. And again, this isn't regulatory arbitrage. It's not we want one regulator or another regulator. Right now, there is no regulatory framework for crypto to trade, to be custodied, to be brokered as a security. We haven't built the plumbing. So we need a rational regulatory framework that does the four things that I mentioned earlier: protects consumers, protects the integrity of the market, keeps bad actors out, but allows the innovation and the entrepreneurship to grow. And we've been very public.
Okay, if anyone has some questions for our guests? Then we have a microphone. Oh.
Thank you.
And while the hands are going up, I'll take a point of personal privilege. I graduated from this law school in 1985. If anyone had told me I'd be sitting here talking about crypto, I don't even think we had email in 1985. We didn't have email, right? So as you're working your way through law school, don't get stuck in, I want to be this type of lawyer or that type of lawyer. Just learn about the law, right? Just learn about what it means to, they say, think like a lawyer and be flexible, because you just don't know where this great career is going to take you.
Hi, again, I really don't know.
No, we need it.
Oh, sorry, my bad. So right now, SEC is trying to regulate a cryptocurrency. A cryptocurrency is not a security. So would you say there is an Article 1 violation where SEC is trying to do more of a legislative job, which is more something that the Congress should do?
Yeah, it's a jurisdictional issue. The Securities and Exchange Commission only has jurisdiction over securities, and they can't expand that jurisdiction to where it doesn't extend. So one of the criticisms that you've heard from some camps after Judge Torres ruled is she was protecting institutional, sophisticated investors, because those institutional sales, but she wasn't protecting retail, the folks that were trading on the Coinbases of the world. That's a false narrative. She didn't say that retail traders are not deserving of protection. What she said was the SEC doesn't have jurisdiction. It doesn't mean that other arms of the government couldn't step in if there was consumer harm, and remember, no allegations of consumer harm in this case. So yes, and there's another doctrine that didn't get a lot of play in our case, but I think it's going to get a lot of play in other cases, called the major questions doctrine. And in this Supreme Court, it's shown up in at least two cases: West Virginia versus EPA, and I think the student loan debt cases, which basically said that if you have a question of major economic significance, then the law is uncertain. That uncertainty can't be filled by unelected bureaucrats sitting in a regulatory seat. It has to be filled by Congress.
Hi, first, on behalf, I guess, of the crypto industry, thank you. I guess my question is more so on the idea of, like, what do you anticipate would have been the supposed best way for the initial distributions of said token to have occurred? Because, like, right now, especially in the wake of the case, many of the discussions revolve around airdrops and other considerations there. Like, also, there also becomes questions of whether or not incentivizing airdrops is a proper way of doing it, or what. But I guess just my general question is, what do you anticipate is the proper way of distributing tokens, if not institutional sales?
So, yeah, I mean, and this is one of the issues that I think we need to resolve either through rulemaking or through legislation. And I think most ICOs, initial coin offerings, which is the reason we don't see them anymore, probably did fit the construct of the Howey case, because when I was selling a token, hypothetically, if I was selling a token through an ICO, I was making a promise that if you buy this token, I was going to do certain things to increase the investment of the token. So I think there are, and then you've exposed the regulatory gap in the law with your question, is I don't think we have a good answer for that one yet. But I think I think probably what we need is some sort of safe harbor, some grace period that allows new projects, new technologies to get off the ground. And to the extent that their token is key to their technology, is key to their product offering, is key to their tech stack, and you need that token for the blockchain to work, then we should have a safe harbor that allows that token to get out into the public. If you're using that token purely as a capital raise in exchange for a promise that if you give me your money and the token is really just a substitute for a right title or interest in my company with a traditional share of stock, then we probably can. So no clear answer, and that's the regulatory gap that we need to fix in the US.
Currently there's confusion regarding which regulatory body can actually regulate digital assets as a whole, including XRP. The CFTC, SEC, and the OCC are all trying to regulate this at the same time. Do you think that the current regulatory framework provided by those regulatory bodies is enough to regulate the digital asset as a whole, the industry as a whole, because of the fact that, you know, assets like Bitcoin or even XRP can be used in all three ways?
Yeah, it's a good question, and it kind of, you know, I've been very critical of the US regulatory system up until now, but we have a very complex system. Those other jurisdictions that I talked about, Singapore, London, the EU, Dubai, you have a central financial regulator that controls all financial activity. Here we don't. We have a Byzantine structure. CFTC for commodities, SEC for securities, OCC for banks, etc. So it does get complicated. But I think what the mistake that the US has made is we have centered the discussion over which agency is going to be the superior or the supreme agency that's going to control this technology, rather than having it be agency neutral and just getting to the right answer. So I think the way the way the other countries have done it is to say, look, is a token a security token? Does it represent a right title or interest in the company, traditional US stock? If it does, that goes to your securities regulator. If it's a utility token, then we'll treat it more like, not even like a commodity. We'll just make sure there's no fraud going on and there's no bad actors going on. Is it a conduit for payment? If it's a conduit for payment, then we'll put it with your payments regulator. So I think that XRP is probably a hybrid of utility token and payments token. And therefore, I think it jurisdiction would probably lie with the CFTC principle. And then to the extent it's used as a payment token between financial institutions, obviously there's money transmitter laws, regulations, et cetera, that would apply. And they apply in any event. We get the equivalent of those licenses before we can do business. And AML, BSA, OFAC, those are table stakes.
I thought that the most interesting distinction between Ripple and Terraform was Judge Rakoff's unwillingness to read how he is distinguishing between different types of purchasers, between institutional purchasers and resale purchasers. I'm assuming you disagree with that. Why do you disagree with that, or do you know?
So it goes back to, I think, what we discussed earlier. I'll give Judge Rakoff the benefit of the doubt, in the procedural posture in that case. Motion to dismiss, 12B6, and answer not even the file, where you have to accept all of the allegations of the claim is true. Given those allegations, the promises that were made to any purchaser of the tokens at issue in that case came with a representation of the promise that there would be returns between 12 and 15% if you bought the token. So the token was not only fungible in terms of its utility, it was fungible in terms of the promises that traveled with it. Whereas in our case, that wasn't the case. And whether or not those allegations can withstand a trial record to certain judgment or trial in Terraform remains to be seen.
If they last.
If they last that long.
Thank you so much for your time. So, well, I had a question about the due process defense in the complaint, and I think as you put it, Judge Torres did not make a decision on that. Do you think that the Court of Appeals might make a decision on that, or do you think this is something that the Supreme Court will touch, given that the decision might change the way that SEC approaches a lot of other things?
I think some of these issues, like the due process argument, like would a person of ordinary intelligence know how what regulatory regimes apply to crypto, given the history of uncertainty that has been fostered by the SEC over the past 5, 6, 7 years. I think that's an issue that would be right for the appellate courts. I think at the trial court level, I think district court judges do recognize sort of the constraint a little bit. So I think at the Second Circuit, we need to take that one on. And I think the Supreme Court, will probably go down to major questions doctrine, as opposed to the due process.
One more right here.
You mentioned earlier the phrase regulation by enforcement, but previously before that, you also mentioned the idea of not picking a fight with the regulators because they can take methods and strategies of drawing out with litigation, et cetera. So in the idea of Ripple only being 11 years old, that's still a relatively young company, and $150 million is not a drop in the bucket either. How do you counsel that company in terms of the future when it's obvious that regulators aren't going to just fly around with this type of decision, trying to find other avenues?
So the way I've counseled the company since the day the lawsuit dropped, and we've been working extremely hard, is to build our business offshore. It's just to move offshore, and practically that's what we've done. And since December 22nd of 2020, we essentially have not signed a single U.S. customer, but the company has never been in a stronger financial and customer position than we've ever been, because we have invested so much in those hubs outside of the U.S. And that's unfortunate. And when I do get calls, which I do, from young entrepreneurs or young lawyers who are representing young entrepreneurs, they ask what advice I have. Don't file your certificate of incorporation in the United States until we can figure this out. It's not the best answer. I think it's a sad answer, but until we figure it out, the hostility to this industry in the U.S. being exhibited right now for this one agency is really it's not something that any company can really survive unless you're really true.
Okay, and on that hopeful note, we're going to have to conclude today, but thank you so much, Stu. This was fabulous.